House Judiciary Chairman Jerry Nadler, anticipating that Mr. Barr over at DOJ will not meet the Democrats' deadline set for tomorrow to release this entire Mueller report. Now, Barr has said, of course, that a redacted version is coming this month, or starting today, I should say, mid-April. Now, today, Nadler set a vote for Wednesday that would move forward to subpoena the whole thing and any other related evidence that Mueller gathered and documents from 5 former Trump White House officials. Nadler making explicit one issue on his mind: obstruction, saying that they want information from these 5 individuals you see on your screen. That includes Don McGahn, who, according to the New York Times, helped prevent Donald Trump from committing what would have been an element of obstruction, the attempted firing of Bob Mueller himself, and Hope Hicks, involved in conversations about responding to reports on the Trump Tower meeting. Her own colleagues have said that she was trying to hide evidence, at least at one point in the process. Then you have Bannon, involved in talks with Trump in the run-up to firing Comey. That's an act that Bannon always claims he opposed from the start.
Walk us through the day he was fired.
Well, the day's fired. I see it on TV like everybody else.
What did you think?
I thought, as I said, I thought it was a big mistake, and I thought it would lead to a special counsel. I mean, I think everything I said at the time basically worked itself out. That was going to lead to a special counsel.
It did lead to a special counsel, and Nadler's saying that is part of why they want to hear from these specific people, including, ultimately, Bob Mueller. Now, Donald Trump's chief of staff, Mick Mulvaney, says that Mueller intended for Barr to intervene on obstruction.
Mr. Barr gets to handle this. That's how the law works. What you saw here is simply Mueller saying, you know what, I'm going to let Barr call this one. He had plenty of evidence to say on collusion, absolutely not, and he actually punted over to Barr. Again, that's the way the system can and does work.
It's certainly one way the system can work. The claim, though, by Donald Trump's chief of staff that they know what Mueller did, that he, quote, punted without having seen the report, leaves open a lot of questions unless they've been briefed by Barr. Now, tonight, the absence of the report appears to be, in its own way, an attempt to try to frame what is in the report, and that is before anyone has actually seen all of Mueller's findings. I'm joined first by Maya Wiley, former counsel to the mayor of New York City and a civil prosecutor from SDNY, and Daniel Alonzo, former federal prosecutor and also former top official in the Manhattan DA's office. And we will turn soon to some other Washington experts. But beginning here, Maya, it does seem like the country has had a speed course in how the DOJ deals with these things. And the big question is, what does it mean that Bob Mueller did the analysis on obstruction the way that Barr says he did?
I think it means we need to see the full report, because the bottom line is you have a special counsel for the purpose of some degree of independence and making the process not a political one, but a legal one. The Attorney General, obviously under the regs, has the power to decide what is turned over, what is made public, or whether to keep it confidential. But in this instance, if you have the special counsel, the person that the public is looking to be the nonpartisan, to not represent anyone else's interests but the interests of the people, and then he punts, you kind of want to know who's spinning the football.
Yeah, I agree with Maya. I mean, it was surprising to me that the special counsel, whose entire job is to be a prosecutor and make a prosecutive decision, decided to punt, as Maya puts it. And I think that we don't know why that is. I don't think Mick Mulvaney knows why that is.
What is a special counsel under these rules, in your view, supposed to do if there is a lot of evidence of obstruction, but the policy is not to indict a sitting president?
I think he's supposed to write that, but that's not what the Attorney General says that Mueller said. He said that Mueller did a little bit of this, a little bit of that, on the one hand, on the other hand, and then he decided not to make a decision and therefore left a vacuum where the Attorney General stepped in.
What decision would that be if you write that out?
Well, if you write that out, the decision could be, you could imagine it being either, hey, there's not enough evidence of obstruction, or, hey, there is enough evidence, and under ordinary rules, I would indict this person, but there's this policy that says you can't indict a sitting president. I could also imagine, hey, this is a really big decision to say that or to decide to charge a sitting president in the absence of that policy and leave that to the Attorney General. I can see that as well.
Yeah, and I agree with Dan. What you can say is, this one's close to the line. It's Congress's call whether or not they think a sitting president should be subject to some sort of process, and certainly make publicly available to the public what, in fact, they found. So the idea here that the Attorney General might hide behind, say, Rule 6E, which is the rule that says you keep grand jury material secret, would hide behind that in order, in this case, after saying he was for transparency, to keep the public from seeing the evidence that Robert Mueller saw that led him to say, you decide.
Well, I would gently push back on Rule 6E. I mean, I don't think the Attorney General has the authority on his own to decide that Rule 6E material, that's grand jury material, which is secret by law, can be turned over to Congress. He needs a court to do that, and it's not clear that a court absolutely has the authority to do that.
Okay, so Dan, you're right. The process is that the Attorney General seeks a court order. There is a precedent for this. It's called Richard Nixon. It's also called Alcee Hastings. Remember Alcee Hastings?
Sure.
Federal judge acquitted of crime, and yet there was a release of grand jury material for the purposes of oversight. So why in this case there would not be sufficient public interest for a court to say, yeah, we're going to find that in this case? I mean, yes, it would be up to the court, but an Attorney General that says they're in favor of transparency would seek the ability to do it.
And I think I'm willing, like Benjamin Wittes wrote today, that we can give him the benefit of the doubt. In other words, let's see what he redacts and let's see what he says his plans are in terms of seeking a court order. I mean, I think there are arguments against the court granting the order, notwithstanding the precedent that Maya cites, but I think that there's a very good argument that they should grant it.
Do you think Bob Mueller wrote the report in such a way that it would be easy to segment out the grand jury material?
Well, we once spoke about that, you and I, and the issue is I would think they would.
I'll never forget it.
If they're being smart, they would do it that way, right? They would write it in a way that it can be cleaved. This is the grand jury information. This is not, so it can be relatively quickly redacted. That would have been what I would think they would do.
And at a minimum, knowing the witnesses, because Congress does have the ability to call witnesses that were called before the grand jury, as Representative Nadler has done, to say, tell us what you know about obstruction.
What does the end game look like on a redaction fight? I mean, if Barr holds the line and a redacted report comes in, the big question is, was it redacted in a fair way, or was it redacted to simply protect Donald Trump and other individuals? What is the end of the line on that? A subpoena fight could take a very long time, but you could subpoena Bob Mueller, and he has some need and interest to show up and say, well, were these fair redactions or not?
Well, Mueller could answer those questions to the Congress. What he couldn't do is say what's under the black tape, right? He's not allowed to do that any more than Barr is.
But can he give a judgment about whether it seems required or not?
Well, this is a gray area. I think different people think of 6E differently, but I would say yes.
Dan, I think it's
I would say
a
yes.
black area.
I would say yes. He should be able to say.
I just want to be clear.
Yeah.
That's a redaction joke.
It's a redaction joke that only a lawyer could love.
Right.
I'm a lawyer. I loved it.
I think that he could be asked, Mr. Mueller, you're familiar with the redactions. Do you believe they are fair? Yes or no? I think probably he could answer that question. I don't think he can say what's under the black tape.
I agree with Dan, and I think if I'm Robert Mueller, I would feel very uncomfortable sitting in that seat, because he's obviously, for whatever reason, made a decision to pull himself out of what may be a political fight.
Right. Well, I think it was also Dan who a long time ago said to me, the action is where the redaction is. Do you remember that? It was a terrible joke you made. I think you made it.
I'll never forget it.
Full circle, kumbaya, and America waits, because really everything that's happened up to even tonight is actually waiting to see what's in those hundreds of pages that Mueller wrote up. Our thanks to both of you for your expertise, Dan and Maya. And we turn now, as promised, in Washington. Former federal prosecutor John Flannery counseled to 3 different congressional investigations, and Julian Epstein, a top lawyer for the House Judiciary Committee during the Clinton impeachment, also dealt directly with the independent counsel's team. Good to see both of you. Flannery, you don't need to make a redaction joke if you don't want to.
I won't.
That's
And not with Mr. Epstein here. We know each other too well.
That's a personal call. I want to dig into the congressional side with you. I just had two experts on a lot of the underlying legal questions. On the congressional side here, what do you think of the way Jerry Nadler is doing this thus far? He's clearly come out pretty aggressively, John.
Yeah, no, I'm 100% with him. And you have to wonder why the 4-page press release that we got from Barr couldn't wait until they had presented a report that we could have immediately. They talk about transparency, but they didn't do anything to accomplish it. And in the letter that was sent in response to Nadler's request that he produce it immediately, one of the categories is they're concerned about the personal privacy and reputational interests of peripheral third parties. Give me a break. What is that, a catch-all to put more black stuff on the page and to redact? I don't think that's clear and transparent. And as for 6E, you have to ask yourself, since so many people were interviewed and not called to the grand jury, how much of a report has to have 6E grand jury material? And I would say a limited amount. And if they were going to make it transparent, why couldn't they go to a court before this point, before that 4-page letter, and get an order to release whatever material they needed to so that the public, the House, and the Senate could see what exactly they were doing? So
well, this is a point you've been exploring from really the dawn of this process, from when we had you on as an expert over that first weekend, is you have been basically arguing that Mr. Barr's priorities, even if they're within the technical rules, have appeared more designed to get a jump on the narrative, to push, as you put it, PR, rather than a deeper consideration of the underlying legal questions.
Yeah, well, it's very interesting that they decry Democrats asking for information about a report that's not been disclosed and calling them political, when that 4-page letter is nothing but political, and it was nothing but a campaign ploy so that our thief executive could go on the road and claim I'm cleared when it doesn't even, in Barr's language, say that.
Well, I'll hit one point on that and turn to Julian. The ending of the probe without indictments on conspiracy does show that he was, whatever word you want to use, not implicated in, cleared on, not criminally charged with conspiracy. That's an important distinction, which is separate from the rest of whatever's in the report. I'll let you rebut, because I see you want to, but I want to bring Julian in first. So coming back to John in a minute. Julian, your views on all the above.
So I just think there are some important facts that your first guest kind of elided over that really need to be put on the table here. In 1974, the House Judiciary Committee got all of the all of the grand jury material during the Nixon impeachment. Leon Jaworski petitioned Judge Sirica, and all of the grand jury material was provided to the House Judiciary Committee. In 1998, during the Starr investigation, we received all of the grand jury material. We received witness testimony, we received videotape, we received all sorts of grand jury material. We received it in early September. We had a team of investigators that spent a month going through it and figuring out, making recommendations to the members, what of that grand jury material should be made public and what should be kept secret. So there's ample precedent for this. The notion that Bob Barr can win a legal fight here, I think, is very, very unlikely. What I think Beryl Howell would do in a case like this, if Attorney General Barr is not willing to do what previous attorney generals have done, particularly in a momentous situation like this, where a situation involves the president, is the House Judiciary Committee would go and try and compel a subpoena. It's a lengthy process, but I think the merits are all on the side of the House Judiciary Committee. And to the extent that there are issues for retaining 6E privacy, most of the reasons for privacy evaporate after an investigation. Sometimes there are some reasons to maintain privacy. One reason would be national security. Another reason might be people's personal privacy, their bank records. Another reason might be ongoing other proceedings. But if there are those concerns, the judge can accommodate those concerns. The Judiciary Committee can accommodate those concerns by doing things like viewing some of the information in camera, having some agreement from the committee not to release public information. So the precedent is overwhelmingly on the side of the House Judiciary Committee here in terms of getting the 6C material and then using some type of process to make sure that stuff that shouldn't be made public won't be made public. But the court can grant it, and I think the court would be likely to grant it. It's just the question for Barr is, do you want to pay me now or do you want to pay me later? Do you want to do it the easy way that's consistent with precedent, or do you want to do it the hard way that's going to make you look like the cat who swallowed the canary, trying to cover something up for a president that is, viewed deeply suspiciously by a majority of the public?
Well, and John, I mean, isn't that the point, that if the redactions are spare and reasonable and well placed, they'll look one way. If it feels like a 400-page report is being significantly cut down through, a Swiss cheese of different redactions, some that are relevant to rules like the grand jury stuff that we just talked about, and some that are just sort of broadly made up, like he just added categories. Won't it really depend what's in there ultimately when this report comes?
Well, Chair Nadler has framed it that if you're not giving it to us, then that's obstruction, and it doesn't surprise us. And I think that the backup of the committee, if they issue, as I expect they will, the subpoenas for the certain named individuals that center around the Comey firing is like a first slice going chronologically from the beginning of our discovery of the misconduct, if you will, by Trump and his acolytes. And so I think that's an important segment. And we do know that they have notes that were supplied to the special counsel during the investigation, and none of those are subject to privilege because it was waived by Dowd and Cobb when they were advising the president and the campaign how to go forward. So it seems to me they have no ability to block either those witnesses or the documents that they have, and that will be very helpful.
Right.
And then I also wonder if we wouldn't do better summoning some of the people who were assistant special counsel in the investigation, who actually interviewed these people outside the grand jury to tell us what they found. You're talking about Mueller's
prosecutors, right? I think a lot of this comes down to whether this is done in a way that people can have some public confidence in which case the pressure builds on Democrats looking like they're trying to do a do-over. You don't need to redo all those interviews if the fruits of it are handled responsibly. Whereas if Barr is seen as doing a deeper kind of dodge, the question is, what are you hiding? If you have nothing to hide, why are you hiding? Hey, I'm Ari Melber from MSNBC. You can see more of our videos right here, or better yet, subscribe to our YouTube channel below. You could have been anywhere in the world, but you're here with us, and we appreciate that.